Thank you. Good morning, everyone. I'm going to call the Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Nguyen.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. We do have everybody present, which means we have a quorum. Thank you, everyone, for being timely this morning. Want to welcome committee members and members of the public who may be watching on the internet or on the YouTube channel to the Assembly Judiciary Committee. Today is day 24 of the 81st session. Before we get started with the agenda, just a few housekeeping rules for those who might be new to the process. If you're on the Zoom with us, if you could please remember to mute every time you finish speaking, that'll help with the audio feedback. And for our presenters this morning, if you could remember to state your name each time before you speak, that'll help our committee secretaries prepare the minutes. I'll try to remind you to do that because I know it's not really a natural thing in conversation. Just a couple other housekeeping matters. We do expect courtesy and respect in our interactions with one another. We might not agree on policy. That's perfectly fine, but we need to make sure we're being respectful of each other and the legislative institution and process. And then finally, many of us are using multiple devices and screens to participate in the Zoom this morning. So please don't see it as a sign of disrespect or inattention if members appear to be looking away at other devices. We're most likely looking at exhibits or just trying to manage this new environment that we're in. So with those behind us, we're going to go to our agenda today. Members, as you can see, we have 3 bills on the agenda today. Just to give a lay of the land, we're going to take them slightly out of order. So we're going to start with Assembly Bill 112, and then we're going to go to Assembly Bill 140, and then finish up with Assembly Bill, I believe it's 125. I've written all over my agenda, so it's hard to read, but the bill listed in the middle will be the last one to go. So, and presenters, thank you for your patience as we navigate this process. So at this time, I'm going to open up the hearing on Assembly Bill 112. Assembly Bill 112 revises provisions relating to compromise claims of a minor. And we have our own Assemblywoman Marzola presenting the bill today. And along with her is one of our former colleagues in the legislature and an alum of the Assembly Judiciary Committee, and that would be Mr. Justin Watkins. So we'll welcome him back to the committee at the appropriate time. And we'll give the two of you a chance to take us through Assembly Bill 112, and then I'm sure we'll have some questions. So Assemblywoman Marzola, please proceed when you're ready.
Good morning, Chair. Can you hear me okay? Good morning, Chair and committee members. For the record, I'm Elaine Marzola, representing Assembly District 21 in Clark County. Thank you for the opportunity to introduce Assembly Bill 112, which revises provisions related to compromise of a minor's claim. To give some context, a compromise of a minor's claim refers to a settlement of a disputed claim for money damages in a personal injury case on behalf of a minor child under the age of 18. In Nevada, if a minor child is injured in an accident caused by the negligence of another person, just like an adult, they are allowed to sue or make a claim and seek a recovery from the negligent party. The existing law in Nevada right now states that if an unemancipated minor has a disputed claim against a third party, the parent or guardian of a minor child has the right to compromise the claim by filing a petition with the court. If the court accepts the petition of the claim of the minor, the court will direct the money to be paid to the parent or the guardians of the minor. Currently, the parents or the guardian must establish a blocked account in a financial investment, a savings account in a depository institution in the state. The revisions in Assembly Bill 112 simplifies and streamlines the compromise compensation process by allowing the parent or the guardian to have more access to the funds of the small claims awards for the benefit and interest of the minor child. Chair, at this time, I would like to turn the presentation over to former Nevada Assemblyman Justin Watkins to present the specific details of the bill and answer any questions about the technical aspects.
Thank you so much, Assemblywoman Marzola. Mr. Watkins, it's great to have you back in the Assembly Judiciary Committee. We wish you were still up here serving with us, but obviously you've gone on to bigger and better things. So it's good to have you back. And when you're ready, please go ahead and take us through Assembly Bill 112.
Thank you, Chairman Yeager and members of the hardest working committee in Carson City. It's a pleasure to be back with you, even if it's on a computer and on TV. And thank you to Assemblywoman Marzola on summarizing the bill. My purpose here is to give you a little bit of context of what this actually looks like in practice, and then I'll walk you through each of the sections of the bill. So the idea behind Assembly Bill 112 is to make this a simpler process. As the Assemblywoman Marzola told you, any claim that is brought on behalf of a minor, it doesn't have to be an injury claim, it could be an assault claim, it could be a neglect claim, any civil claim that is brought on behalf of somebody under the age of 18 by a parent or guardian can only be settled and resolved by permission of the court. And that permission is sought through a petition in which the court is advised of what the insurance limits are, how much the attorney is going to bill for fees, what the litigation costs are, any other payments that have to come out of that, say to medical providers and the like, and then what's going to be left for the minor and where they're going to deposit those funds. The language that's currently in law as to the options available for depositing the funds into a blocked account are a little antiquated. And to go a little bit backwards in this bill, the cleanup language is actually in Section 1, Subsection 8, in which we're taking out the language of a depository institution and moving that to a financial institution. This will give the courts a little bit more clarity and breadth for the types of investments that the parents would like this money to go into. It will remain blocked. It can only go to the minor at the age of 18 upon a petition by the minor once they reach the age of majority. But this would allow them to put it into annuities, and there are, I'd say, inconsistencies in the state as to what types of financial institutions this could go into because of the language of depository. So some courts have read that to mean it actually has to be a savings account in a bank. And currently, as I'm sure every member here knows, the interest rates associated with a savings account are not great. So if you put in $1,000 for a 14-year-old, 4 years from today, it's likely to be $1,020. The money is not growing at the rate it should. Whereas if they were to put it into a mutual fund, a guardian fund, the interest rates are much more likely to be in the 4 or 5% rather than the less than 1%. The substantive change that Assembly Bill 112 looks to make is in subsection 5 of Section 1. In other states, and I know because I practice in California, they have streamlined the process of when the minor is going to get an amount of $5,000 or less, that they expedite the process. You still have to do a petition to the court like you would here, but they make the process much simpler, and there's a lot more leeway given to the parent or guardian and how that money is assigned. Here in Assembly Bill 112, what we sought to do is create a line of $2,500. If the minor is going to get a settlement and the amount in their pocket is going to be $2,500 or less, we wanted to give more freedom to the parents to decide what is best for their child for that amount. We think with that lower dollar value, the likelihood of abuse by the parent of the funds is much less, and this would actually encourage the parents to bring the claims. In practice, what I see is that on low dollar value cases, say where the minor is going to get $500 or $1,000 or $1,500, oftentimes the parent won't actually even bring the claim because there are a lot of things that they're signing on to with the court. When they settle a claim and make this petition to the court, they are signing on to yearly accountings with the court to show exactly where the funds are, what the interest has bared, and they have to continually make yearly appearances, either in paper or in writing, with the court to tell them what's going on. We feel that for these lower dollar amounts, allowing that money to go directly to the parent to be used for the benefit of the child, it doesn't have to go into a savings account. It may be after some trauma, they want to take the child on a trip or a vacation, or they want to buy that child something that is meaningful to them to help in the recovery, or otherwise. We think the parents are in the best place to determine how to spend those low dollar amounts rather than the court, and the immediacy of the availability of those funds is much more beneficial to the minor than, say, 4, 6, 10, 14 years down the road when they turn 18. And so in summary, this is largely a cleanup bill to give more options available to the minor through their parent and guardian. And we think that the return on investment will be greater with this kind of language. And on top of it, we think that this will encourage the parents and guardians to bring the claims on behalf of the minor rather than waiting until the minor turns 18 and the minor bringing the claim themselves. And I thank you for your time, and I'm available for questions.
Thank you so much, Mr. Watkins, Assemblywoman Marzola. Before I open it up for questions from others, Mr. Watkins, I think you might have mentioned this, but I think I just missed it. You had mentioned that you practiced in California, and I had wondered did you tell us what the threshold is there for these type of claims that don't have to go through this more thorough process? And if you did, I'm sorry I missed it. If not, could you let us know?
Thank you, Chair. Justin Watkins for the record. Yes, in California, the threshold is $5,000. In there, they have an expedited process, and they still must put the money into a block trust account. And I'll note, for purposes of clarity for the language of AB 112, it is optional for the court to, under $2,500, to give the money directly to the guardian or the parent. They still can order it go into a block trust account if the court deems that necessary.
Thank you so much for that response. I know I have a question so far from Assemblywoman Cohen, so we'll go to her and then we'll take additional questions.
Thank you, Chair, and thank you, Mr. Watkins. It's good to see you. I think you just answered my question, actually. I was a little concerned about when you have parents in a joint physical custody situation, because the language says that the money is going to go to the custodial parent and doesn't say whether it's physical or legal custody. And again, you can have a joint situation. However, if there's a dispute, then the court would be able to make the determination. So I was just a little concerned about opening us up for more litigation with parents going to family court saying, oh, well, she took the $2,500 or he took the $2,500, and did something they weren't supposed to do, but I think you've pretty much resolved that issue for me. So thank you.
Are there other questions from committee members? If you could raise your hand. Okay, I see we have Assemblywoman Kasama. Before we go to her, anybody else with questions at this time? Okay, I don't see any. So I see Assemblyman Ornlicker. So we'll go to Assemblywoman Kasama, then Assemblyman Ornlicker, and we'll see if there are other questions. So please go ahead, Assemblywoman Kasama.
Thank you, Chair. My question is, since you brought it up, in California, they're using the $5,000 and we're using a $2,500. Should it be higher? How did that amount, how was that arrived at? Just curious.
Thank you, Chair. Through you to Assemblywoman Kasama. Justin Watkins for the record. I think that we were trying to make an adjustment for different dollars in different states and cost of living and what I thought was appropriate. To be frank with you, in my practice, I think that at $5,000, I don't ever see parents avoid making that claim due to the hardship of reporting to the court. But when you start getting down to $2,500 and under, I see parents delay or not actually pursue the claim. So it's just a number that I'm in practice, I thought sort of hit the mark.
Well, since it's your expertise, then I'll go with that, but I was just curious. Thank you.
Assemblyman Ornlicker.
Yes, thank you, Mr. Chair, and thank you, Justin Watkins, for presenting. You said on one hand, the parents don't bring the claims. You'd also said something that made me think that the child, upon becoming an adult, could bring the claim. But are you worried about justice delay can be justice denied? Is that part of it?
Thank you, Mr. Chairman, through you to the Assemblyman. You hit it exactly right. Yes, a minor has the permission or has the right to bring a claim for 2 years. We'll assume it's an injury claim. Statute of limitations is 2 years. They have the right to bring that claim for within 2 years of when they turn the age of majority. So 20 years old on an injury claim. But if the child's 6 years old and we wait 14 years before they bring the claim, the likelihood of a recovery to the benefit of the now minor child turning majority in a fair value, I think is next to zero. I've been practicing in this area for 17 years, and I haven't seen a claim brought like that was to the benefit for being delayed.
Do we have additional questions for Assemblywoman Marzola or Mr. Watkins? Okay, I don't see any additional questions. So I want to thank the two of you for presenting. We'll give you a chance to wrap up after we see if there's any testimony on the bill. At this time, I'm going to open it up for testimony in support of Assembly Bill 112. Don't believe we have anybody on the Zoom in support, but if I'm wrong about that, if you could turn your camera on and simply wave. I don't see that happening. So BPS, could we go to the phone line to see if there's anybody there who'd like to testify in support of Assembly Bill 112?
Good morning. Thank you, Chair. For callers wishing to provide testimony in support, please press *9 now to take your place in the queue. Callers wishing to provide support in testimony of Bill 112, please press *9 now to take your place in the queue. And Chair, there are no callers in support at this time.
Thank you, BPS. I will close testimony in support. I will now open it up for testimony in opposition. Don't believe we have anyone on the Zoom who'd like to testify in opposition. BPS, could we check the phone line to see if there's anyone there?
Thank you. For callers in opposition, please press *9 now to provide testimony for opposition. Callers wishing to testify in opposition, please press *9 now to take your place in the queue. And Chair, we do not have any callers in opposition at this time.
Thank you, BPS. I'll close opposition testimony. I will now open neutral testimony. Don't have anyone on the Zoom in neutral. BPS, could we check the phone line to see if there's anybody neutral on the bill?
Yes, thank you. For callers wishing to testify in neutral, please press *9 now to take your place in the queue. Callers wishing to provide neutral testimony, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no callers for neutral position at this time.
Thank you, BPS. I will close neutral testimony. I noticed Assemblyman Wheeler seemed to have his hand up. Do you have a question or a comment, Assemblyman?
Just a quick comment, Mr. Chairman. I just wanted to welcome Assemblyman Watkins back to his old committee and tell him I kind of miss our cigars and arguments. So good to see you back.
Thank you, Assemblyman Wheeler. Okay, so we didn't have any testimony, but Assemblywoman Marzola, Mr. Watkins, want to give either of you a chance to provide any concluding remarks on Assembly Bill 112 if you'd like to. Do you want to go ahead, Assemblywoman? I think you're both waiting. I think you're both waiting on each other. So why don't we start with you?
We are.
And then we'll go to Mr. Watkins. Please go ahead.
I just want to thank you, Chair and committee members, for the opportunity for allowing me, both myself and Justin, to introduce Assembly Bill 112. If anyone does have additional questions or comments, please feel free to reach out to me. I'll be more than happy to answer any questions that anyone has. And thank you again.
And thank you, Chair and members of the committee. It was a real thrill to be back with you guys. And thank you for the kind words, Assemblyman Wheeler. I appreciate it. I miss the same things. And best of luck to all of you for the remaining of the session. Thank you.
Thank you both so much for Mr. Watkins in particular for joining us at 8 a.m. this morning. We appreciate it. With that being said, I'm going to close the hearing on Assembly Bill 112. Committee, we got through that one pretty quickly. I'm not sure what the next two are going to be like, but we'll see. So at this time, I'll go to our second bill on the agenda. I'm now going to formally open the hearing on Assembly Bill 140, and I should specify that's our third bill on the agenda listed, but our second one we'll be considering today. Assembly Bill 140 enacts provisions relating to service of process on certain lessors of vehicles, and we have our own Vice Chair Wynn, who will be presenting this bill, and we also have Mr. Justin Randall joining us on the Zoom, and I think he will be presenting as well, or at least be providing some supportive testimony. So welcome, Mr. Randall, welcome, Vice Chair Wynn, and when you're ready to proceed with the presentation, please go ahead.
Thank you. For the record, this is Rochelle Wynn. I represent Assembly District 10. And like many of the best bills, they come directly from our constituents. They arise organically from conversations that we're having with our neighbors. And in this case, Assembly Bill 140 comes after a conversation I had with my neighbor, Allison Brazier, at a block party about issues she was having in our state, helping her clients who were injured in accidents where the person that had caused the injury or the accident was a foreign national or someone that lived outside of the United States. With that, I will turn this over to Justin Randall. He's been working with me to come up with language that captures this, that makes us in line with a lot of other states that already do this. And this is his first time testifying before the legislature. So please pepper him with as many questions as you can. And I know he's very excited because he is a constituent of our chair. And so he's excited to present. So with that, I'm going to turn this over to Mr. Randall.
Thank you, Chair Yeager and Vice Chair Wynn. Much like Assembly Bill 112, this is a cleanup measure for essentially what's a loophole in our service of process that we have currently. If in the event that we have someone who comes from another country and visits Nevada, they rent a car, for whatever reason, they're required to purchase the liability insurance that the rental car agency provides for any uninsured people that are driving their cars. Upon purchasing that rental car insurance, what they then do is drive on the roads. In the event that they get in an accident, that insurance applies and covers them in the event for any damages they've caused. What happens later is where it gets complicated. So typically after they cause an accident, they turn and leave the state, leave the country, and go back to wherever they are from. In the event that we're unable to settle the claim that's made on behalf of the injured party in the state of Nevada, we're forced to file a lawsuit. And as part of that lawsuit, we're required to serve the defendant. And this is where it gets complicated and we have somewhat of a loophole. So if the person who caused the damages or injuries was a Nevada resident or a United States resident, we can either serve them personally within the United States or serve them through alternative service means. What I mean by an alternative service mean is in the state of Nevada, we have several options. First, we could serve them by publication. If we're not able to physically hand them a copy of the lawsuit, we can serve them through the DMV, which essentially authorizes the DMV to accept service on their behalf if they're driving on the roads within the state of Nevada. Where it gets complicated, again, is if they live outside of the country. And in that instance, we really only have two options. First, we can either serve through the Hague Convention, which is extremely complicated, cumbersome, and costly, and lengthy. And that's only if the person who caused the damage is a resident or citizen of a country that's a signatory to the Hague Convention. If they're a resident of a country that's not a signatory to the Hague Convention, it gets even more complicated in that we don't really have a good way to serve them. So ultimately, often a plaintiff in that circumstance has very little recourse to get their damages compensated by the person that harmed them. Now, this gets even more complicated in the event that we are required under Hague service to have a valid address for the person. And I can tell you 9 times out of 10, if people are exchanging information or if there's a police officer that responds to the scene, we rarely have a valid address. Often we'll get part of an address. We may get a country, we may get a street, but we might not have a city. I can tell you I have a case right now where the address that the police officer wrote down was a city in France, for example, Paris, and then the country was Belgium. Well, those can't be the same. And we don't know where they live, so we have to serve in both places or attempt service in both places. And this gets very costly very quickly. So this can cost on the low end between $1,000 and $3,000, if not more, and can take sometimes a year or two just to get through that very basic procedural step of serving process. Now, like I said, we have the DMV service in the event that the person is a United States citizen or a Nevada resident. We don't have any option like that for a foreign resident, and that's essentially what this bill does. So what this bill does is it allows the rental car agent, or requires the rental car agency to accept service on behalf of any foreign insured that they have written a policy for and allowed to drive their vehicle on the roads in Nevada. Basically, what happens is they will be, the plaintiff will serve the rental car resident agent with the process, and then they're required within 30 days to forward that to their insured. And they're in the best position to do this because when they rent the car, they're collecting the information, they're collecting the driver's license number, they're collecting the contact information. They know how to get a hold of this person. So they are in the best position to forward the service to them so that we can get the judicial process started and going for the injured party. Now, we're one of the few states that does not have this law that deals with high tourism. This law is actually very, very similar to a law that's been enacted in California and a law that's been enacted in Florida. So these are long-standing laws that have been in each of these states, and we've reached out to our cohorts in other states, our colleagues that have said there's no issues with this law. The insurance companies know how to deal with it. The plaintiff attorneys know how to deal with it. Essentially, what we're doing is just cleaning up a loophole that allows an injured party that's injured by no fault of their own in the state of Nevada to get the justice they deserve. And with that, I'll receive any questions.
Thank you so much, Vice Chair Wynn. Mr. Randall, I've often said that for the lawyers on the committee and for those watching, we should get continuing legal education credits for this committee. And I give you points, Mr. Randall, for being the first one to mention the Hague Convention, which I think is a first in my 3 sessions on the Assembly Judiciary Committee. So well done on that front. I suspect I have questions from others. I have one quick question while it's on my mind. You answered most of what I was wondering about, which was the cost and the time that it takes to serve someone overseas through the Hague Convention. But what I'm curious about is normally when we file a lawsuit, we have 120 days to serve the other party. And it sounds like when you have to go through this process, it can take years. So I just wondered, in that circumstance, are you having to go back to the court essentially every 4 months to ask for additional time? Or is there something in our statute that allows you more than 120 days to try to serve a foreign national overseas?
So there's nothing in the statute that extends the time. We are required to go back to the court every 120 days, which quite frankly is a waste of judicial resources. We have judges deciding this motion, the same motion, over and over and over again, just because of the extended time it takes to serve the defendant through the Hague Convention.
Great, thank you. And that was Mr. Randall for the record. I think our secretary probably knows that because you're the only one speaking, but I'll make that clear just in case. Committee members, any other questions that you have for Vice Chair Wynn or Mr. Randall, with a reminder that it's his first time here in the Judiciary Committee. So if you're not sure whether you should ask that question, you definitely should ask that question. Anyone out there? Might get off easy today, Mr. Randall. Oh, I see one from Assemblywoman Bilbray Axelrod. Please go ahead.
I just couldn't let him go without a question. I was just curious on how often we see this. Is this a problem that is occurring often, or is this a rare case, but obviously just something that needs to be addressed?
Thank you for your question, Assemblywoman Bilbray Axelrod. This is Justin Randall for the record. I will tell you, I'm a partner in a small 4-person law firm, and I think me alone in my law firm have about 5 to 7 cases right now in the past year where this has happened. So this is not a small issue. This is something that happens on a regular frequency to an injured party in the state of Nevada.
Great. So it looks like I have questions from Assemblywoman Summers Armstrong, and then we'll go to Assemblywoman Miller. Assemblywoman Summers Armstrong, please go ahead.
Thank you, Chair. Thank you, Mr. Randall. Just a follow-up question to Assemblywoman Bilbray Axelrod. Will this bill allow you to, is it retroactive? Will you be able to apply this procedure to your existing cases, or will this only be for cases going forward? Would be my question.
Thank you for your question, Assemblywoman. This is Justin Randall for the record, and there's nothing currently in the bill to make it retroactive. However, I believe once the bill, in the event that it's passed and signed into law, we would be able to ask a judge through a motion to apply this to a prior case as an alternative means of service.
Thank you.
All right, let's go next to Assembly Member Miller.
Thank you. Thank you for the presentation. And I know we had a chance to get a lot of my questions out the other day when we spoke. You mentioned that the bill is similar to bills in other high tourism states. How does our bill different from theirs? Thank you.
Thank you, Assemblyman. At this point, it's identical to the California statute. I believe it is slightly different from the Florida statute, but they are virtually the same. It's just slight wording changes that we made. But in terms of substance, they're identical bills.
And just for the record, sorry, Assemblywoman Rochelle Wynn, some of the changes that are different from the Florida and the California just have to do with our existing procedural rules here in our state.
And this was Justin Randall speaking before.
That's okay, Mr. Randall. We often forget to do that, so thank you. Anyone else with questions before we open up for testimony? I see Assemblywoman Kasama. Please go ahead.
Sorry, a little trouble today with my machine. So just curious, in essence, and the insurance company pays the claim, and then it's up to them if they want to pursue the person overseas, or do they? I'm just curious. Do they actually go that far, or do they just pay the claim and settle it?
So it's not exactly as that. Actually, let me step back. This is Justin Randall for the record. It's not exactly how that works. So what happens is when they purchase the insurance policy through the rental car agency, the rental car agency actually indemnifies and defends the lawsuit. So once we serve the person, so we serve through currently The Hague or however it's allowed in the country that they live, they will then get a lawyer from the insurance company for the rental car agency. And typically they're self-insured, but the lawyer will then represent the defendant, so the actual person who caused the harm, and then they will also pay based on whatever the coverage of the policy is and the value of the case. So they're not specifically being represented, or they are being represented by an insurance company, regardless of the method of service.
I see. So then whatever, let's say a deductible based on their insurance plan, they'll be responsible for too. So it's the insurance company's attorneys that deal with it, and then they deal with the person who rented the car.
Thank you. This is Justin Randall for the record. Typically what will happen is they will assign an outside attorney. So it's not necessarily an attorney that works specifically for the insurance company, but they will hire and pay for an attorney to represent the defendant. On this type of policy where it's a one-time use, a rental car policy, there's typically not a deductible. You're just paying a daily rate or an hourly rate, however you rent the car, for the coverage of that time frame.
Thank you so much for answering the question. Thank you, Chair.
Thank you.
Thank you, Assemblywoman. And now you'll have some good questions to ask next time you rent a vehicle and they want you to sign that waiver saying you're declining the coverage. You'll be able to ask them how much the daily or monthly rate is. And maybe you can even ask about the Hague Convention and see if they know what you're talking about. Assume they will not. Assemblywoman Hanson has a question. Let's go to her next.
Thank you, Chairman. Thank you, Mr. Randall, for being here. Let me get I'm trying to see you. I don't want to talk without looking at you. So I just want to clarify that it is mandatory right now that if somebody from another country comes here, I'm thinking, with all of our tourism, that they do have to get the insurance coverage, right? I heard that correctly?
Yes, this is Justin Randall for the record, Assemblywoman. That is correct. They're required to purchase it, and this bill doesn't change anything about that. This only changes the method for service of process.
Right, and then we're just looking at, with this bill, instead of going through The Hague and going through this foreign process, this bill would allow the process to go, you serve the lessor. And then it just cuts out that foreign aspect of it, and you deal with the lessor, the rental car agency per se. Correct?
Yes, this is Justin Randall for the record, and yes, that's correct. Essentially, the lessor, the rental car agency, is required to accept service on behalf of their insured, the foreign driver, and then they just forward it to the foreign driver within 30 days, and the process proceeds normally from there.
Perfect. Thank you for clarifying for me.
Thank you.
Additional questions for Mr. Randall or Vice Chair Nguyen? Okay, I don't see additional questions. I did want to let the committee know that I was fact-checked, that we have mentioned the Hague Convention in the past few sessions in the context of child abduction and child custody cases overseas. So I was wrong, but I know for many of us, we don't remember that. So I still am impressed by the reference. So at this time, I want to thank the two of you for presenting. We'll give you a chance to do some wrap-up testimony at the end after we take testimony on the bill. For now, I'm going to go to testimony in support of Assembly Bill 140. Don't believe we have anyone on the Zoom with us in support. BPS, could we check the phone lines to see if there's somebody there who'd like to testify in support?
Thank you, Chair. For callers wishing to provide testimony in support on AB 140, please press star 9 now to take your place in the queue. Callers wishing to provide support in testimony of AB 140, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 037. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Tanya Brown, TonjaBrown, private citizen. I'm in support of this bill, and I'll tell you why. Some years ago, I had some friends that were home sleeping in their beds when a vehicle drove through their bedroom wall. These people were from out of the country. They caused a lot of damage to the house. The woman sustained major injuries. They were unsuccessful in getting those individuals to be sued. They had to go through their homeowner's insurance to recoup any monies from the damage that had been done. So I would be very much in favor of this bill. Thank you.
Thank you so much for your testimony, Ms. Brown. We appreciate that personal story. BPS, anybody else in support of Assembly Bill 140?
For callers wishing to testify in support of Assembly Bill 140, please press star 9 now to take your place in the queue. And Chair, there are no further callers wishing to provide testimony in support.
Thank you. I will close testimony in support. I'll now open up opposition testimony. BPS, I don't see anyone on the Zoom who wants to offer testimony in opposition. Could we check the phone lines to see if there's somebody there?
Yes, thank you. Callers wishing to provide testimony in opposition of Assembly Bill 140, please press star 9 now to take your place in the queue. Callers wishing to provide in opposition, please press star 9 now to take your place in the queue. And Chair, there are currently no callers in opposition for AB 140.
Thank you, BPS. I'll close opposition testimony. I will now open neutral testimony. We don't have anyone on the Zoom in neutral. BPS, can we check the phones to see if there's anyone there who'd like to offer neutral testimony?
Thank you. Callers wishing to provide testimony in neutral for Assembly Bill 140, please press star 9 now to take your place in the queue. Callers wishing to provide testimony in neutral, please press star 9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no callers to testify in neutral at this time.
Thank you, BPS. I will close neutral testimony. One last call before we go to concluding remarks from members. Any questions or comments on AB 140 that you've thought of in the last few minutes? Okay, I don't see anything. So Vice Chair Nguyen, Mr. Randall, I'll give you a chance to make concluding remarks. And just so it's a little easier on the Zoom, why don't we start with Vice Chair Nguyen and then we'll go to Mr. Randall.
I will just wave to Mr. Randall.
I just wanted to thank the members of the committee for allowing us to speak here today. And I would just like to highlight that Ms. Brown's comments are exactly the type of scenario we're trying to prevent here. This happens much more than I think people realize within the state of Nevada, given our significant numbers of tourism in a normal time. And that situation is exactly what happens and what we'd like to prevent through the passage of this bill. So thank you again. And if you have any questions, please let me know.
Thank you so much, Vice Chair Nguyen, Mr. Randall. Mr. Randall, I will tell you that normally if it's your first bill, we require a song and dance of some sort in concluding remarks, but we're going to let you off the hook today. And you did a great job presenting your first bill in the committee. So thank you for being here and please enjoy the rest of your day.
Thank you.
So with that, I'll close the hearing on Assembly Bill 140. Committee, that one went pretty quickly too. I have a feeling the next one's going to take a little bit more time on the agenda, which is why we held it for the end. So I'll now open up the hearing on Assembly Bill 125. Assembly Bill 125 revises provisions relating to credits against sentences of offenders. And we have one of our Assembly colleagues, Assemblywoman Duran, with us here on the Zoom. And I believe she is joined by Mr. Pirro and Ms. Birchie, and they are going to collectively present Assembly Bill 125 to us, and then we'll have a chance to ask questions. And I think we'll probably have quite a bit of testimony on this bill as well. So welcome to the committee for the first time in this session. I think maybe the first time ever, Assemblywoman Duran, and welcome back, Mr. Pirro, Ms. Birchie, and whoever would like to start with the presentation, please go ahead.
Good morning, and thank you, Chair Yeager and members of the committee. Yes, this is my first time, a little nervous. But anyway, for the record, I am B. Duran, representing Assembly District 11. I am here today to present for your consideration AB 125, which revises provisions relating to credits against sentences of offenders commonly referred to as good time credits. First, I'm going to give you a little background on good time credits, and then I will turn the discussion over to Ms. Birchie. Excuse me, hopefully I don't butcher your name, and Mr. Pirro for further comments. So a little background information. Existing law allows offenders to have no serious infractions and who perform duties assigned in a faithful, orderly, and peaceful manner to earn credits to reduce their sentences through good behavior, educational attainment, and or successful completion of certain treatment programs. The last time good credits were substantially revised was in 2007 with AB 510. This bill doubled the amount of credits that an offender could earn. One of the reasons the bill was introduced was to reduce prison overcrowding by encouraging offenders to earn good credits to reduce their sentence. There is still much to do, and this bill before you attempts to balance public safety, offender rehabilitation, and fiscal responsibility. I want to clarify a few things for the committee. First, this bill will not apply to individuals who have been convicted of violent offenses, sexual offenses, or felony drunk driving. Moreover, I've listened to the concerns of the opposition, so I am proposing a conceptual amendment which takes into account some of the opposition's concerns. The conceptual amendment would preclude habitual offenders or people who commit residential burglary from receiving good time credits off their minimum sentence. I am also open to working with the opposition as well to address some of their concerns. Mr. Chair, with your permission, I would now like to ask Assemblywoman Nguyen, Ms. Birchie, and Mr. Pirro to offer their comments before we move to questions.
Thank you so much, Assemblywoman Duran. You did a great job. There's no reason to be nervous. Before we get to Ms. Birchie and Ms. Pirro, I just wanted to confirm with you. I didn't see an exhibit on Nellis, but I think what you're proposing today is a conceptual amendment that would, just want to confirm for the record, so that this bill would not apply to somebody who has been deemed a habitual criminal or somebody who is serving a sentence for a residential burglary. Is that correct?
Correct. And Mr. Pirro could follow up on those. I think we made a list of the ones that are going to not be included in this bill. I believe Mr. Pirro can get that for you.
Great. Thank you so much, Assemblywoman. Mr. Pirro, are you up next? It looks like it, so please go ahead.
Thank you, Mr. Chairman and members of the committee. John Pirro from the Clark County Public Defender's Office. Well, this is a bill of a few red ink marks, basically one. It has a big impact, and I want to talk a little bit about what it does. Well, many individuals are behind bars for only a short period of time. The backbone of mass incarceration is people serving very lengthy sentences, often decades long, and far longer than they would serve for comparable crimes elsewhere in the world. Nevada was heading down that trend, incarcerating our population 15% higher than neighboring states and similarly situated states before the passage of AB 236 last session. That led to an emerging recognition that overused imprisonment has heightened calls for change. This bill takes the next step forward as a tune-up to AB 236, addressing Category B felonies, in order to truly dismantle a mass incarceration system that has made us no safer and taken up larger and larger portions of our state budget. That being said, I want to explain first how good time credits actually work. In Nevada, people are sentenced to a range as opposed to a fixed number. For example, instead of just saying a person is sentenced to 10 years in prison, they could be sentenced of a range from 1 to 10 years. So if a judge sentenced somebody to 4 to 10 years in prison on a category B felony, the minimum part of the sentence, the start of it, is 4 years. The maximum part, the back end, is 10 years. They would only get credit on the back end of the sentence for good behavior, not on the good front end. Any good behavior on the front end, they would still do day for day on that 4 years. So I want to explain that. They would do 365 days a year for 4 years. That's 1,460 days. Or for any fans of the Broadway musical Rent, that's 525,600 minutes by 4 years, which makes 2 million minutes away from children in need of a parent, away from aging grandparents and parents, or more recently, 525,600 minutes spent in a COVID incubator as Nevada's prisons have become over this pandemic. As Assemblywoman Duran said, I want to be clear about a few things. You only get good time credits for good behavior, educational programming or workforce programming, or attending a treatment program. In other words, trying hard to become a better person upon your release and rehabilitate yourself so that when you are released, you can come back into society and do things better. Only those people trying to do better and be better will get credit. If you get an infraction, if you don't complete your programming, if you don't do anything to make yourself better while incarcerated, you will not get good time credits, not on the front end of your sentence or the back end. Now, I want to pass it over to Ms. Birchie to explain a few other things that this bill does, if that's okay, Mr. Chairman.
Thank you, Mr. Pirro. That would be fine. Ms. Birchie, welcome back, and please go ahead.
Thank you. Kendra Birchie with Washoe County Public Defender's Office. What I want to make clear about this bill is that it will not apply to individuals who have committed a violent crime against another person, a sexual offense, and with the Conceptual Amendment, it will also not apply to those who have been deemed to be a habitual criminal or those who enter another's home to commit a crime and felony DUIs. Section 1, subsection 8 of this bill specifies the offenses where an individual is not eligible to receive the deduction in their minimum sentence for good time credit due to their conviction. Subsection 8D removes the category B felony from this preclusion if it is a crime that is not a crime of violence, sexual offense, or felony DUI. Those charges are already statutorily determined ineligible from receiving good time credit. The Conceptual Amendment adds habitual offenders and people who commit residential burglaries from that as well. When the Crime and Justice Institution evaluated our state's prison population, they found that 66% of people who were in prison were there for nonviolent crimes, and 4 out of 10 of those had no prior felony convictions, meaning over half of our prison population consisted of nonviolent offenders. Section 2 sets forth a path to try to make our criminal justice system a little more fair and more equitable for the men and women who are sentenced to a term of incarceration before AB 236 went into effect. According to the data from 2019 from the Department of Corrections, it's still more than half of our prison population, both male and females, are serving time on a Category B offense. I want to highlight some of the inequities. There are women currently serving time on a Category B offense for possession of a stolen motor vehicle, for driving, not stealing, just driving a vehicle that they knew or should have known was stolen that is worth more than $3,500. Now, if someone committed that exact same crime today, it is a Category C charge, punishable 1 to 5 years in prison. Now, that woman who is already in custody on the Category B charge would serve a longer sentence, even if she were working harder and doing all the programming than someone who's currently convicted and sentenced to prison on that same exact charge. So even though that first person's working harder, she'd end up serving longer. We can correct this inequity through Assemblywoman Duran's bill. An even bigger distinction is with individuals sentenced to drug-related offenses. Again, 70% of females are in custody on drugs or property-related offenses. So no crime of violence and not involving a victim in terms of that there was a violence upon a victim. As such, this bill will have a dramatic impact on women involved in the criminal justice system. The request to give these mothers, sisters, and wives the ability to receive good time credit simply makes sense. It costs us all $25,000 a year to house someone at NDOC. That's more than we're spending on educating a student. We can continue the progress that we made last session. All this bill does is allow for people trying to better themselves to be rewarded for trying to change, be better, and do better. This bill is both fiscally sound policy and good criminal justice policy. Now I'd like to turn back to Mr. Pura for some closing remarks, if that is okay with you, Chair Yeager.
Thank you, Ms. Birchie. Please go ahead, Mr. Puro.
Thank you, Mr. Chairman. John Puro for the record. The last thing that I wanted to talk about before we close it out for questions is Marcy's Law. The benefit of being here for the 3 sessions now is I was here when Marcy's Law passed. And you may hear that some category B felonies target elderly people or victimize vulnerable victims. We have enhancements for those. So if you have an offender that targets a vulnerable victim or an elderly victim, they have to serve consecutive time, meaning that if they get 1 to 10 years in prison, they have to finish that prison sentence and then serve another 1 to 10 year consecutive prison sentence or whatever the judge decides before they would even be considered for release. Sometimes Marcy's Law is used as both a sword and a shield, depending on what's more convenient at the time. But what Marcy's Law really is a recognition that a victim of a crime should be allowed to participate in the process and be given notice of all the important parts of the process. In this light, a victim has already had the chance to say their piece at sentencing if they were informed by the DA to be present there. And they're also informed of parole board hearings. So nothing this bill does is going to automatically release people from prison. They still have to go before the parole board and be evaluated by the parole board for their good behavior before they would even be eligible for release. And Nevada pays a lot of money for what's called the VINE system. And that informs victims of any upcoming procedures or processes that will be taking place in an incarcerated person's case. So the victim will still have a chance to say their piece and be informed. So there's nothing this bill does that is offensive or to Marcy's Law in our Constitution. I just wanted to make that clear. All this bill does is allow people who are trying to better themselves be rewarded for trying to change, be better, and do better. Thank you, Mr. Chairman.
Thank you, Mr. Puro. Before we open it up for questions, I just wanted to say a couple of things. One, I wanted to ask either Mr. Puro, Ms. Birchie, or Mr. Rand, after the hearing today, could you submit those conceptual amendments in writing so that we can make sure they're uploaded to the website so that we have those?
Absolutely, Mr. Chairman.
Kendra Birchie for the record, yes.
Great. And then 2 other points of clarification I wanted to make, just because we have some new members on the committee to this session and some new folks to the legislature. Mr. Puro referenced Marcy's Law. Marcy's Law is the name for essentially rights that victims have in the criminal justice system. So there was a resolution that went through the legislature in the 2015 session and the 2017 session. And then the voters approved those constitutional amendments at the 2018 ballot. So our Constitution includes some rights that victims have in the criminal justice system. And that whole set of rights is sometimes called Marcy's Law. So you'll hear those interchangeably. And really that just means the constitutional rights that the victims have. And then finally, Mr. Puro mentioned the VINE system. And so that is an electronic automated system that victims of crime can sign up to receive notification. And that acronym stands for Victim Information and Notification Every Day. So if you're interested in that, if you can just Google VINE and Nevada, you'll see how that works. But folks can get signed up to get basically updates on how when an offender's due for parole, whether they might be released. So I wanted to make those clarifying remarks. I know I have a few questions already, so here's how we'll start the queue. I have Vice Chair Wynn, Assemblywoman Cohen, and then Assemblywoman Bilbray Axelrod, and I'm sure we'll have some more after that. So please go ahead, Vice Chair.
We talked a little bit, or you talked a little bit about Marcy's Law and the fact that this was not going to interfere with victims' ability to be present during sentencing. This law is not suggesting that people be resentenced. Is that correct?
John Puro for the record, that is correct, Madam Vice Chair.
The other question I have has to do with the passage of Assembly Bill 236 during the 2019 legislative session. Can you kind of give some examples in the area of drug trafficking and drug charges on how they differ today as, you know, prior to the passage of that bill? I know that during one of our presentations by Director Daniels, he talked about his willingness to try to figure out ways to get rid of or, you know, safely depopulate some of our women's prisons because of these non-violent drug offenses. So can you speak to a little bit about that and the inconsistencies and how this law would change that?
John Puro for the record. I'll let Ms. Birchie answer that question if that's okay, Madam Vice Chair.
Kendra Birchie for the record. So specifically, if someone had, let's say, 4 grams of methamphetamine before AB 236, that was considered trafficking amount. So even if it's just the possession for personal use, it was a trafficking amount, which was a mandatory prison sentence of 1 to 6 years. With AB 236, again, we took a look at that and realized that we needed to do something to change to work on the overcrowding in the prison population, as well as provide those individuals with the treatment they need, because again, it's a non-violent offense for a drug charge. And so what we did was that's now a category E felony where it is deemed to be diversion eligible and mandatory diversion to provide them with the treatment necessary to be successful.
And was it previously a category B felony? So someone serving that 1 to 6 years would not be eligible to earn good time credit?
Kendra Birchie for the record, yes, Vice Chair Nguyen, it was a category B felony. And so they would receive no good time credit off of that minimum sentence.
Thank you. I don't have any further questions.
Okay, thank you, Vice Chair Nguyen. So I have some additional questions. So just so everyone knows the order we're going to go in, we have Assemblywoman Cohen, Assemblywoman Bilbray Axelrod, Assemblywoman Hanson, and then Assemblyman O'Neill. So please go ahead, Assemblywoman Cohen.
Thank you, Chair, and thank you all for the presentation. My question is about in Section 1, a lot of subjective words that are used. For instance, Section 1, Sub 1, there's reference made to no serious infraction of the regulations. And in Sub 2, there's diligence in labor and study merits, referring to an offender whose diligence in labor and study merits. In Sub 4, diligent and responsible manner is used. Sub 5, exceptional meritorious service. Then in Sub 6, there's reference to the board adopting regulations. So are those regulations determining what those subjective terms mean? I know there's some reference to the director making some of the determinations, but it just seems it's very subjective. And if you can just address how that determination is made, or if it's just, if the director just gets to make the subjective determination for each instance.
John Puro for the record, Assemblywoman Cohen. That's a great question, and frankly, Director Daniels would probably be the best person to answer it. But as I understand it, it's up to the wardens of whatever prison that are making those decisions, and the associate wardens. So it is a very subjective standard currently.
Okay, thank you. So if you're if you're in prison and you just get on the wrong side of the warden, you're just, there's really no place to go from there.
And Kendra Birchie for the record, again, I think hopefully Director Daniels, I wish we were all in the room because then he could be able to provide his information for this. But I did speak with individuals from the prison yesterday who did inform me that what happens is when someone does commit an infraction and they're considering removing the good time credit, they'll have a disciplinary hearing where I use hearing lightly because it's not in front of the judge, where they'll then be able to address whether or not those good time credits should be removed.
Okay, thank you. Chair, can we see if Director Daniels is on the phone?
We'll have to wait until we get to his testimony if he's on the phone. We don't have him on the Zoom, but if he's there, we'll ask him at that time if he can answer some of those questions. Okay, let's go next to Assemblywoman Bilbray Axelrod.
Thank you, Chair. And I just had a question for Ms. Birchie. You had said something about, and I just kind of wanted a clarification because I am new to the committee. You said something about if someone steals a $3,500 car or drives a $3,500 car that they should have known was stolen is a category B felon, but then after last session, I think you said now it's not. Could you just explain to me? So yeah, could you just kind of clarify that for me as well? You said it quickly and I started to write it down, but if you could just go over that again, I'd sure appreciate it.
Kendra Birchie for the record, absolutely. So there's a current charge in statute for possession of a stolen motor vehicle. So you don't have to be the person who actually stole the vehicle, but if you are in possession of that vehicle, like if you are driving the vehicle, and before AB 236, depending on the amount that the car was worth, it could be a category B felony. That was one of the things that we took a look at, and based on our data decided that it was more appropriate to reduce that charge. And so now it is a category C felony and the value is not the same. So it doesn't matter for the value.
Just quick follow-up.
Go ahead.
And so AB 236 did not do anything retroactive. So currently there are people in prison with a category B for driving a car that was worth $3,500. Is that correct?
Kendra Birchie for the record. Yes, you are correct. And that's exactly one of the inequities that we're hoping to change through Assembly Bill 125.
Thank you.
Let's go next. I think Assemblywoman Hanson indicated that her question was answered. So we'll go next to Assemblyman O'Neill.
Thank you, Mr. Chair. And because we're having problems with signing on and we don't know who may be in queue, I just wanted to ask, who did you work with to make the conceptual amendments?
If I could, John Pirro for the record. Assemblyman O'Neill, so we listened to some of the concerns that the district attorneys had, and we're trying to address those concerns through the conceptual amendment. And still, with Assemblywoman Duran's permission, open to working to make this a bill that works for everybody.
Very good, thank you.
Okay, do we have other questions from committee members? If you could raise your hand in front of your camera or otherwise indicate that you have a question. Okay, I don't see additional questions at this time. Assemblywoman Duran, Mr. Pirro, Ms. Birchie, thank you for presenting. We'll give you a chance to do some wrap up after we take testimony. And so at this time, I'm going to go to testimony, and I'll let members know I do have a number of folks who are signed up to testify, most in support, but I think we have some in opposition and perhaps some in neutral. I think we have enough time to get through all that testimony, so we will do our best. But as a reminder to those who will be writing testimony on the phone, ask you to please limit your comments to 2 minutes so we can make sure we get through everybody who'd like to speak on the bill. So at this time, I'll open up testimony in support. I don't believe we have anybody on the Zoom with us in support, but I'm pretty sure we have a number of folks on the phone. So BPS, could we go to the phone line and take our first caller in support of the bill?
Thank you, Chair. For callers wishing to provide testimony in support for Assembly Bill 125, please press *9 now to take your place in the queue. And we will begin with caller with the last three digits of 695. Caller with the last three digits of 695, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Thank you. Good morning, Mr. Chairman. This is Holly Welborn, Policy Director for the ACLU of Nevada. Thank you very much to Assemblywoman Duran for bringing this forward. I won't say too much. My colleagues at the Public Defender's offices did an exemplary job of really laying out the reasons why the ACLU supports this. But I want to talk a little about the work that I have done with many members of this body, with my colleagues at the PD's office, on Category B felonies, examining Category Bs and their disproportionality and how that disproportionality drives up our prison population is not a new concept in the state. We've been talking about it for decades. During the 2015-2016 interim, my first interim with the ACLU of Nevada, I was appointed to the Advisory Commission on the Administration of Justice. And at that time, we examined over 200 Category B felonies, and from that list recommended approximately 13 to 25 different crimes for recategorization to a Class C, noting that the major difference between a C and a B was eligibility for sentencing credits. But that proposal, unfortunately, was rejected. Thankfully, AB 236 moved us in the direction we needed to go. We developed a permanent sentencing commission and created the Department of Sentencing Policy to evaluate and overhaul the sentencing structure as a whole. I see this bill very much as a complement to those efforts to adopt smart justice policies throughout the state of Nevada to drive down our prison population and save the state millions of dollars in incarceration costs. So for these reasons, we strongly support this legislation. Thank you.
Thank you for your testimony, Ms. Welborn. BPS, could we go to the next caller, please?
Thank you. Caller with the last three digits of 779. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Yes, hello, my name is Nicole Cox, Nicolecox from Assembly District 2. I'm calling in support for AB 125. Prior to incarceration, my husband had always been a hardworking man and in fact had been working 2 full-time jobs prior to leaving, just to assist in supporting our family. While he was gone, he had continued to work as a porter in the prison and has also completed several programs to assist in bettering himself. He has had no write-ups and fractions and is spending most of his time planning for our future and family life in the coming years to come. He has planned to continue his education and continue working to provide for his family. He is and has always been an integral part of this family, and to say he has been missed and is needed at home is an understatement. The passage of AB 125 would not just help him, but would help many others who are purely just trying to do their best to better themselves and provide for their families. So I sincerely hope that we pass AB 125. Thank you. Bye.
Thank you for your testimony, Ms. Cox. BPS, let's go to the next caller, please.
Thank you. Next caller with the last three digits of 667. Caller with the last three digits of 667, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Hello, my name is Nelda Wegant, NELDAWEYGANT. My husband is currently incarcerated at NDOC. My husband was sentenced to 10 to life as a habitual criminal. My husband has made many mistakes in his life, and I know that he must pay for what he's done. I am very sick and have 3 daughters, my youngest age 2. I think that she might not know her dad is terrifying. My husband is at NDOC working as a porter. He has no write-ups and is trying to do everything right. He knows that without him, our family is incomplete and broken. Before his incarceration, he was working and providing for his family. My husband is an essential part of our family. I am here to support the bill AB 125 because my husband needs hope that one day he will be free and able to once again provide for his family and to learn to become a better member of society. I support this bill and can only pray that upon passing, this will not only give my husband, but all the other people who are at this time hopeless, enough hope to not give up. Please pass AB 125, not only for my family, but for all the other families who are suffering without their loved ones. Thank you.
Thank you for your testimony, Ms. Wagon. BPS, let's go to the next caller, please.
Next caller with the last three digits of 037. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. We strongly support this bill. This is something that is long overdue. I'd like to also echo the comments made by Mr. Perro, Ms. Birchie, and Ms. Welborn. And yes, thank you very much for bringing this bill forward. Have a good day.
Thank you for your testimony, Ms. Brown. BPS, let's take the next caller, please.
Thank you. Next caller with the last three digits of 123. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Hi, my name is Shuri Slothamer, Lothamer. I am in support of AB 125, which would impact my loved one as well as many others hugely. This bill would possibly bring my loved one home up to 8 years sooner. In the last few years, he has received his high school diploma, took culinary classes, then returned to assist in teaching them, all while continuing to have a job as the unit laundry and being write-up free. When he was home, he was a caring and loving father, son, and hardworking. He worked as a construction worker and had his own teams, which he managed. Having the chance to bring my loved one home years sooner would be able to bring our family back together again, showing him and many others that people do believe in rehabilitation, and this would impact them hugely. I am fully in support of AB 125, an opportunity it gives people at the chance of returning to their families sooner for doing the work needed on themselves. They should be rewarded for that, and AB 125 gives them that motivation to do so. Thank you.
Thank you for your testimony, Ms. Lothamer. BPS, let's take the next caller, please.
Next caller with the last three digits of 209. Caller with the last three digits of 209, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
First name is Ashley, A-S-H-L-E-Y. Last name is White, W-H-I-T-E. Good morning. My name is Ashley, and my fiance is currently incarcerated. I am here to support this bill because I believe it would benefit him and other individuals as well. He is considered to have a Class B felony, but does not fit the Class B felony criteria in his case. He has done over 90% of his sentence and is due to expire soon. He is working and doing everything he can to get home quicker. He has done everything that has been asked of him through programs and classes. This current situation is making his depression and anxiety increase, and he has had to increase his medications as well. He just wants to come home and be able to help raise his young children. With this bill, it would help give individuals an incentive to put effort into doing their time to prepare themselves when they are free. Right now, for many of them, like my fiance, he feels like no matter how hard he tries, there is no real way out. This bill would give him hope, and sometimes hope can sustain you. I do support this bill. Thank you.
Thank you for your testimony, Ms. White. BPS, let's take the next caller, please.
Thank you. Next caller with the last three digits of 080. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Hi, Jim Hoffman for Nevada Attorneys for Criminal Justice. We support this bill. We're thankful to the sponsor for bringing it. I would like to make the point that, the people who've just testified, their partners are the ones who already want to be rehabilitated, who want to do that work to become productive members of society. And that's great and that's important, but we know that there are also people in prison who have trouble finding that motivation. Because a lot of people, the reason they're in prison in the first place is that they think about short-term consequences. They think about immediate rewards, and they're maybe less good at thinking about the long-term impact of their actions. So good time credits are a really important tool for reaching those people, convincing them that they need to rehabilitate themselves, because it aligns their short-term incentive of, getting their freedom back with their long-term incentive of becoming a productive, healthy, capable member of society. So aligning those short-term incentives with the long-term incentives is ultimately going to produce more rehabilitation to be better for society. And we support this bill. Thank you.
Thank you for your testimony, Mr. Hoffman. BPS, let's take the next caller, please.
Next caller with the last three digits of 130. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning. My name is Christine Saunders. That's CHRISTINESAUNDERS, and I'm the Policy Director with the Progressive Leadership Alliance in Nevada. I just want to echo the sentiments of those who spoke before me. This is a good bill that, as you have heard from the families who have testified, will make a meaningful difference in people's lives. We wanted to add our support for AB 125 to the record. Thank you.
Thank you for your testimony, Ms. Saunders. BPS, let's take the next caller, please.
Thank you. Next caller with the last three digits of 606. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Hello, my name is Amber Cannon, AMBERCANNON, and I am in support of AB 125. I currently have a loved one incarcerated in the Nevada Department of Corrections on a Class B felony. While he does have a few years left to be completed, he's been doing all that he can to make sure he can transition into a successful member of the community. Unfortunately, the time he has been incarcerated has taken a huge toll on his mental health. There are phone calls that I spend being his counselor and talking him through his depression and PTSD for him to just make it through the day. He has not received any write-ups and complies with his programming so that he can come home as soon as he can. I know that he is not alone. There are others who suffer the same fate. The longer they are in the corrections system, the higher the risk of developing mental health issues or exacerbating those they already have. In support of this bill, you are showing these individuals that you are watching them make the right steps in the right direction and supporting all of their efforts. Thank you.
Thank you for your testimony, Ms. Cannon. BPS, let's take the next caller, please.
Next caller with the last three digits of 499. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Hello, my name is Jody Hocking, JODIHOCKING, and I represent Return Strong, Families United for Justice for the Incarcerated, and our over 1,000 members, both inside of MDOC and families outside. I'm the founder of Return Strong and also part of an impacted family. My loved one is incarcerated at Southern Desert Correctional Center and has done most of his adult life at MDOC. Not because he's a horrible person, but because from a very young age, his life was shadowed by the incarceration of his family members, their addictions, and the resulting trauma that doesn't always lends itself to great decision-making. I often think of how his life could have been different if he'd been born at a different time or a different place in a different society that invested in restorative practices, as opposed to being born in a state that uses punitive measures and incarceration as a primary method of dealing with unwanted behavior in society. It's time that Nevada does better by incarcerated people, and AB 125 takes a large step in that direction by recognizing that there's opportunity for growth from all people, by acknowledging that no one should be judged forever by a moment of poor decision-making, by providing the opportunity for people to demonstrate their own capacity for change and rewarding that work and allowing them to earn the chance of a life outside of prison to redeem their own stories. We recognize that AB 125 is just one way that we can help to balance the injustice and disparity that currently exists. We fully support AB 125 and the Assembly sponsors and co-sponsors for this courageous steps towards a more just Nevada. Thank you.
Thank you for your testimony, Ms. Hocking. BPS, do we have other callers who'd like to testify in support?
Yes, Chair. And we will go with caller with the last three digits of 826. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning. My name is Ayana, AYANNA Simmons, SIMMONS, and I thank you for this opportunity. And I too have a loved one, several, incarcerated in Nevada Department of Corrections. I am here today to express my gratitude to the Assembly members who brought this bill to the table. This is desperately needed in the state of Nevada. However, we have a huge number of people who made decisions as young people, decisions that were often made under duress, and not because they are inherently bad, but because they were trying to survive and didn't necessarily have the guidance or the means to do so. And in the circumstances under pressure, you don't always make the best decisions. With that being said, we definitely need to, as we apply this bill, consider the mental illness amongst the inmates who are repeat offenders. We also have a system in place that gives excessively long sentences and also give those same excessively long sentencing disappropriately to young Black men. AB 125 is an opportunity to give people in a chance to do something different, to take different paths and have a different ending. They can't change what happened, but they can start where they are and build a different ending. AB 125 allow them the opportunity to believe in a life outside of prison. And with that being said, with those who have been sworn and taken an oath to the Constitution and the obligation for morality, again, we are Nevada strong, we're battle born. We can do this together and address the problems and the issues that reoccur. And again, I want to thank you for your time and allowing me to address this and putting this on the table. I am representing many families that can't be here today, but we are in full support of AB 125. And again, with that, I close. Thank you.
Thank you for your testimony, Ms. Simmons. BPS, could we take the next caller, please?
Yes, thank you, Chair. Next caller with the last three digits of 395. Caller with the last three digits of 395. And we are not getting a response. Oh, caller with the last three digits of 395, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
My name is Catherine Greco, CATHERINE GRECO, and I am in support of AB 125. Good morning, Assembly members. Thank you for listening to us. My daughter is an inmate at Florence McClure Women's Correctional Center. She went to prison for DUI. She has never been in trouble before. She was my easy child. But one night, one poor decision has impacted her life and the lives of another family forever. She has never been incarcerated. She has been incarcerated since June of 2016, almost 60 months for what was pled down. Whitney would be one of the people that would benefit from AB 125. She has already served close to her minimum and has now done everything that she can to get her time. She was in college working on her associate's degree when the accident happened. Since receiving her sentence in 2017, she has received her associate's degree while working as a porter on property at Casa Grande. She also has received 18 A's and is currently enrolled in UNLV, finishing up her bachelor's degree in communications. My daughter is someone who took responsibility for her mistake and has done everything she can to improve herself during her incarceration. She's a great example of what can be accomplished when everyone works together. I feel that people deserve a chance to build a new life after incarceration. That night should not be the sum of her life. This bill gives people who have been convicted of B felonies an opportunity to show their growth and be given a chance to redeem their story. I am in support of AB 125 and given good time credits to people with Class B felonies. One law makes it hard for the person that didn't ever do anything wrong, never planned on anything ever happening, would have never went out if they would have known this was going to happen to them. And now, because of a certain way the law reads, they're excluded from AB 125. Very unfair for someone who has never been in trouble in her entire life and is trying so hard to be a decent person in society. Thank you.
Thank you for your testimony, Ms. Greco. BPS, do we have anybody else on the line in support?
Thank you, Chair. We are in support for Assembly Bill 125. If you have recently joined the call and would like to testify in support, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 117. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning. My name is Nicole Williams, NicoleWilliams. I am here in full support of AB 125. I have an incarcerated loved one, and I agree with points that others have made in support. Thank you.
Thank you for your testimony, Ms. Williams. BPS, do we have other callers in support?
Yes, thank you, Chair. Next caller with the last 3 digits of 640. Caller with the last 3 digits of 640, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
My name is Jan Salvay, JanSalvay. Thank you for letting me speak today in support of AB 125. I'm calling on behalf of my nephew who was incarcerated in Nevada, who recently passed away, unfortunately. He was supposed to get out in October, but because they stopped the work program, they kept adding time to his sentence. And they delayed his release all the way up till a month ago. And he was diagnosed in June with hepatitis C and refused treatment because they said he was getting out too soon. I'm sad to tell you this, but he passed away on Sunday. His goal, he's always been a hard worker, but suffered from mental health issues and substance abuse. And he was with me for 4 weeks, and we kept trying to get him health care and getting ID and all this stuff. And the treatment kept getting put off. So he decided to go to Florida to see his 2 children, 10 and 12. They had dinner at night, and he passed away sometime in that night. There's an autopsy pending, but he was very, very sick. And he told me over and over again while he was incarcerated, please get me out of here, find out what's going on with me medically. He was panicky, and I talked him through it, and I kept trying to call people. And basically, they added another month to his sentence. They said they made a clerical error in October of 2014. And it was torturous, honestly, for him and for our family. And then for him to finally get out and to just literally die. And I was very excited to hear about this bill because I want to do everything I can to support families who are still in there, who are suffering, and it's just really unfair. So I'm very excited about this, and I'm so grateful for all of you that are in support, the legislatures and the families. And that's it. Thank you so much.
Ms. Salve, we're very sorry for your loss. Appreciate you calling in support today and providing your testimony. BPS, do we have any other callers in support?
Yes, Chair, thank you. Caller with the last 3 digits of 534. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Hello, my name is Areli Rodriguez, AreliRodriguez. While my brother is incarcerated, he wouldn't be impacted by this bill. But I am speaking today on behalf of another family whose loved one would be impacted. But they can't be here, and they asked me to tell their story. First, thank you for creating this bill. It is important to so many people and will receive hope in a hopeless situation. Losing your physical freedom is horrible. But for so many people that are incarcerated, the hopelessness is what also leads them to just give up. Today, I want to share a story of a loved one who has
had a long time issue with abusing drugs and alcohol. Since the beginning of his addiction, he has always been sent to prison repeatedly. He didn't get help or alternative sentencing or restorative justice options. Prison was the only answer that we had to address his substance abuse issues. He has never had violent felonies. Everything was in relation to his addiction. Now he is doing a very long sentence for a habitual crime. What if somewhere along the way we dealt with the real issue, which wasn't criminal? It was related to his mental health and addiction. AB 125 is one small way we can do the right thing as a society and as a community. Give people the opportunity to earn back some of their life. Myself and my family are in full support of AB 125 and are so happy to see our legislators doing the right thing for our incarcerated population. And although I understand this won't help the person I am talking about because it's habitual, I just want to make sure to tell their story. Thank you.
Thank you for your testimony, Ms. Rodriguez. BPS, are there additional callers in support?
Any further callers wishing to provide testimony in support, please press *9 now to take your place in the queue. For callers wishing to provide testimony in support of AB 125, please press *9 now to take your place in the queue. And Chair, there are no further callers for testimony in support.
Thank you, BPS. I will close testimony in support, and I will now open up testimony in opposition. I don't believe we have anyone on the Zoom in opposition, but BPS, let's go to the phone line. I believe we might have one or more there to testify in opposition.
Thank you, Chair. For callers wishing to provide testimony in opposition, please press *9 now to take your place in the queue. For callers wishing to provide testimony in opposition of Assembly Bill 125, please press *9 now to take your place in the queue. And we will go with caller with the last 3 digits of 648. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Thank you, Chair Yeager, members of the Assembly Judiciary Committee. My name is John Jones, John Jones, here on behalf of the Nevada District Attorneys Association. We are in opposition to AB 125, but we have begun a dialogue with both Assemblywoman Duran and Vice Chair Nguyen regarding our concerns, and we look forward to further discussions regarding this bill. As previously stated, Category B felonies are designed to be significant crimes against the person, property crimes with a higher value threshold, substantial identity fraud cases, or crimes involving a significant public safety interest. Over the years, we have reviewed these offenses to make sure only the most severe are listed as Category B felonies. There is more work to be done, but because of the severity of these offenses, DAs have opposed efforts to apply credits to the front end of these sentences. Credits can reduce a sentence by approximately 40%. But if a judge tells a victim, due to the serious nature of these offenses, that the defendant will serve a minimum of 12 months, then the entire 12 months should be served prior to the defendant being eligible for parole. We appreciate Assemblywoman Duran accepting part of our suggestion with respect to residential burglary, but there are still several other very serious offenses that would now be eligible for front-end credits, including child neglect, elder exploitation, possession of firearm by felons and domestic abusers, and others. None of these crimes have an element of use or threatened use of violence, and thus would be entitled to credits under AB 125, and we strongly oppose this. Persons convicted of these and other crimes should serve the minimum sentence in its entirety. And I also want to say, be very skeptical when people say nonviolent crime. Residential burglary, for example, someone coming into your home, ransacking it, violating the place where people feel most safe, is defined as a nonviolent offense in the state of Nevada. And as I've previously referenced, other examples of serious offenses can be considered nonviolent. Section 2 of the bill makes the application of these good times credits to the front end of a sentence retroactive. It's our opinion that Section 2 violates the truth in sentencing laws and the spirit of Marcy's law by significantly changing a defendant's sentence without input from the victim. When a defendant is sentenced to a Category B felony, victims are told that the defendant will serve at least the minimum sentence before being eligible for parole. If AB 125 were to pass, a defendant could parole out of prison having spent significantly less time in prison than a victim had been assured at sentencing. Defendants are not opposed to applying credits to low-level felonies, and over the years we have engaged in efforts to move lower-level felonies to Category C, or even lower, thus allowing credits to be applied. In fact, last session we agreed to reduce quite a few Category B felonies to lower offenses, and we feel this reclassification process is a better way to accomplish a similar goal. With that, Chair Yeager, I look forward to continuing this discussion with Assemblywoman Duran and others, and I appreciate your time. Thank you.
Thank you for your testimony, Mr. Jones, and always appreciate your willingness to continue the dialogue to see whether there might be common ground there. So please, I'll just ask you and Assemblywoman Duran to keep us updated as those discussions go forward. BPS, do we have anybody else on the line who'd like to testify in opposition today?
Thank you, Chair. We are in opposition for Assembly Bill 125. If you have recently joined the call and would like to testify in opposition, please press star 9 now to take your place in the queue. For callers wishing to provide testimony in opposition of Assembly Bill 125, please press star 9 now to take your place in the queue. And Chair, there are no callers for opposition at this time.
Thank you, BPS. I will close opposition testimony at this time. And I did just get a request. I think there was a question for Mr. Jones, but I think he is no longer on the line. So I would encourage members, if you do have questions for Mr. Jones in opposition, please reach out to him, email him, call him. I assure you he will get back to you in a timely manner. So seeing no further opposition, I'll close that testimony. Let's go to neutral testimony. I don't think we have anyone neutral on the Zoom with us today. BPS, could we check the phone line to see if there's anybody there who is neutral?
Yes, thank you, Chair. For callers wishing to provide neutral testimony for Assembly Bill 125, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 556. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT. I support the bill. I'm sorry, I hit the wrong time. Thank you.
Thank you for your testimony, Ms. Grant. We'll ask our committee secretary to note that your testimony was in support of the bill. We will go back to neutral. BPS, could we check the phone to see if there's anyone neutral, please?
Yes, Chair, thank you. For callers wishing to testify in neutral of Assembly Bill 125, please press star 9 now to take your place in the queue. Callers wishing to provide testimony in neutral of Assembly Bill 125, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, there are no further callers at this time.
Thank you, BPS. I will close neutral testimony. Committee members, as you probably noted, we didn't have Director Daniels or anybody else from the Department of Corrections on today. That's no slight on them. They're not required to be here. But Assemblywoman Cohen had some questions about how some of existing law works. So Assemblywoman Cohen, I would encourage you to reach out to the Department of Corrections, not to put too much work on her, but I also believe Vice Chair Wynn knows quite a bit about how the law actually works in terms of what you're reading in the bill that is not changes to existing law. So she's a good resource to reach out to as well if you're not able to connect with the Department of Corrections. So with that behind us, let's go ahead and take any testimony, any wrap-up testimony. We always try to give presenters the last words on their bill. So Assemblywoman Duran, Ms. Birchie, Mr. Pirro. Looks like Assemblywoman Duran is unmuted, so I'll let her go first and then we'll take it from there. Please go ahead.
Thank you, Chair Yeager and committee members, for considering Bill AB 125. We do look forward to working with Mr. Jones on his concerns and with the help of Mr. Pirro, Vice Chair Wynn, and Ms. Birchie. And thank you, and we'll get back to you, and if you have further questions, we will be available, and we urge your support for AB 125. Thank you.
Thank you, Assemblywoman Duran. Mr. Pirro, Ms. Birchie, would you like to say anything in closing?
John Pirro for the record, very briefly, Mr. Chairman. I think one of the callers summed it up best. You can't change what happened, but you can begin again and create a better ending. This bill encourages people on Category B felonies to do just that, and we urge its passage.
Thank you. Ms. Birchie?
Kendra Birchie for the record. Just thank you so much for allowing us to present this bill, and we look forward to working with all stakeholders. Thank you.
Hey, thank you to the three of you for presenting Assembly Bill 125 this morning. Appreciate it, and please have a great rest of your day. I'll now close the hearing on Assembly Bill 125. Committee, 3 bills in less than 2 hours, so I feel proud about that. Proud about our work today. I wasn't sure if we were going to get through all 3 of these. We did, so that's a good sign for things to come in processing the work in front of us. I'll now go to our final agenda item, which is public comment. By way of reminder, we will reserve 30 minutes for public comment at the end of each meeting. Callers on the public comment line will have up to 2 minutes to provide their public comment. VPS, could we go to the public comment line and see if there's anybody there who would like to give public comment this morning?
Yes, thank you, Chair. For callers wishing to provide public comment, please press *9 now on your phone to take your place in the queue. And we will begin with caller with the last 3 digits of 037. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. I don't recall the woman's name, but I would like to send our sincere condolences to her and her family over the loss of her nephew. She touched on something that I have an understanding of, we'll say. Over the years, I have seen inmates trying to get help for hepatitis C and being put on the back burner because of their parole tag. And simply, if they are coming up for a parole hearing, it's one way that they get around not doing medical treatment for these individuals. And then they'll come up for the parole board hearing, and then they will get a dump. And then again, they'll have another parole tag hearing coming up in another 2 years or a year, or whatever the case may be. And then they will be given a dump again, and no treatment starts. And normally they don't start the treatment until it is too late. And by that time, their disease has progressed. And it's too late, and they die. And this is something that really needs to be looked at. Thank you very much, and have a good day.
Thank you for your public comment, Ms. Brown. VPS, do we have anyone else who'd like to give public comment this morning?
We will go with caller with the last 3 digits of 556. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was killed by Reno police, hogtied for 40 minutes and asphyxiated by Washoe County deputies in October of 2015. The medical examiner in my brother's case said my brother would not have died but for the restraint and physical force used against him. Today I want to talk about another asphyxiation death that occurred at Washoe County Jail. Nico Larom Smith was 31 years old when he was asphyxiated at Washoe County Jail 8/29/2015. The inmate death rate was 5 times the national average when Nico died a horrible, torturous death at the hands of Sergeant Corey Salfarino, Brandon Wood, who I believe is the deputy who had surrounded me and my family at the jail when we were holding a banner, Emmanuel Figueroa, and multiple unnamed deputies. Nico was taken into custody at a bail bondsman, clearly in the midst of a mental health crisis. He thought his girlfriend was trying to poison him with peanut butter cups. According to deputies, Nico attempted suicide while in the jail cell. He was actually dunking his head in the toilet. Deputies ran in and stopped him. Then 6 to 8 deputies surrounded Nico, who was prone face down with 2 kneeling with their full weight on his back, cutting off his ability to breathe. No deputy attempted CPR. Nico was a father of 1 young son, a brother, a son, and a friend to many. I have gotten to know Nico's brother, Romeo Smith, through our shared nightmare. He too hopes for transparency and accountability and for no other family to know this unnecessary nightmare. Please do not support bills that protect bad police. Please support bills that promote transparency and accountability. And I too would like to send my condolences to the caller who lost her nephew at the jail. Thank you. Or recently who died from lack of treatment. Thank you.
Thank you for your public comment, Ms. Grant. BPS, anyone else for public comment?
Any callers wishing to provide public comment, please press *9 now to take your place in the queue. For callers wishing to provide public comment, please press *9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no further callers at this time.
Thank you, BPS. I will close public comment for the meeting. And thank you, BPS, for making that all happen today. We had a number of callers on that last bill we heard, and thank you for managing all of them and getting them all connected and able to testify. We appreciate the hard work that you're all doing to make these virtual meetings a reality. Okay, committee, anything else from any committee members before we talk about the rest of the week? Okay, I don't see anything. I want to thank you guys again. I'm very impressed that we got through those 3 bills in 2 hours. So I think that speaks to the homework that you all did last night to be prepared for these bills. And as chair, I really appreciate that. So please continue to do that as the session gets busier. So tomorrow we are starting at 9 o'clock rather than 8 o'clock. And our own Assemblywoman Gonzalez is going to be presenting a bill tomorrow. I think it's going to be her first bill presentation. Assemblywoman Marzola showed us the way this morning with her first bill presentation. So we look forward to that. Just so members know, I'll remind you tomorrow, but at some point tomorrow morning, I'll be presenting a bill over in Government Affairs. So I may have to hand the meeting off to our able vice chair if I'm being called to jump on a different Zoom, since I don't think we can be on 2 at the same time. And then for Friday, just so you know, we are going to have a meeting Friday. We're going to start at 8 o'clock on Friday. Vice Chair Wynn is going to be presenting a bill, and we are planning on a work session on Friday after the bill hearing. We're still finalizing that document, but I think it's safe to say that we'll probably be voting on somewhere in the neighborhood of 7 to 10 bills. So look for the agenda to come out indicating what those bills are. And then for new members to the committee, just so you know, we put together a work session document. It basically summarizes the bill and any proposed amendments to the bill. So you'll have that to refresh your memory because you may not remember a bill we heard 2 or 3 weeks ago. And we'll make sure that members of the committee get that document well in advance of the meeting. It'll be sometime tomorrow, so it won't be the morning of the work session. You'll have some time to look at that. And my request of you is just to let me know if there's something on there that you're not comfortable with, or if you're planning on voting no. Please let me know that. when we do the work session, we'll have time to answer questions and make sure that everyone knows what they're voting on. So that's what Friday looks like for now. So again, a reminder, tomorrow is 9 o'clock, Friday is 8 o'clock. We are working on agendas for next week, but we don't have any of those ready yet. So I'm not ready to tell you what next week's going to look like. I should have more information for you tomorrow or Friday. Okay, that was way too much talking. So with that being said, I hope everyone has a really wonderful day, and I will see you all tomorrow morning in this committee at 9 o'clock. This meeting is adjourned.
Bye. Thank you, Chair.